So thank you for this. So let's just move on quickly. So what I'm going to do is just very briefly tell you who I am, who I work for, what our involvement in dispute resolution is, so you've got some idea as to why you're listening to me. Then I want to take you through how we've seen mediation evolve and what we've moved into. And then if we've got time, just some of the ways in which we as an appointing agency are actually using our mediators now outside the normal sort of traditional form of mediation that I think we all used to. So Joe, could you go on to the next one? I've asked Joe to do the slides because we've got Virgin Media here in Rugby and I keep on getting a sign saying how bad my internet signal is. And when I try and run it, the whole thing falls apart. So I'm in charge of the RICS Dispute Resolution Service. I know I recognize a few of the names on today, so some of you will know who we are. But in essence, within the RICS, which is the Royal Institution of Chartered Surveyors, there is a fairly independent, it's 45 years old now, section of RICS, which is a dispute resolution service. We made about 5,000 appointments last year of, the whole way across the board, arbitrators, adjudicators, experts to expert determination, mediators, dispute board members, the works. And we operate all the way around the world. So I mean, this morning started at 7 o'clock with a call to China. India, we're working in Canada at the moment, becoming a adjudication nominating authority in all of the provinces. We work in Australia, more the way around the world. And I think if you measure the work that we do in terms of the number of appointments we make, the sort of 700 people that we got on the president's panel, the stretch that we got geographically, and we're probably at the moment making about 75% of the adjudication appointments in the UK, and we named in 99% of commercial leases. So we are, I think quite safely the oldest and the largest built environment specific dispute resolution and avoidance service provider anywhere around. So again, Joe, if you wouldn't mind going on to the next one, I'm not going to subject you to that, but if you are ever at an entirely loose end and you want to see something quite amusing, go and have a look at the film that we did on dispute resolution service when we had our 40th anniversary a few years ago. It's a little bit dated, but it's quite fun. So let's move on again, please, Joe. So just briefly, the way it works is that we train up adjudicators, arbitrators, mediators, and so on. They then go through an interview process, come onto the president's panel, and we then match them to disputes. And we also obviously run the quality assurance bit, which is the codes of conduct, the standards, the disputes, the complaints process, and ultimately the disciplinary process that can lead to them being removed from the president's panel if we feel that the way in which they've conducted themselves isn't satisfactory. So again, let's move on. And that's it. I mean, it could probably sound better in an American accent, but in a sense, that's what we're about. We, as the RICS, it's what we offer is expert dispute resolution in the built environment by built environment experts, and we only work in the built environment. If somebody comes along to us with a workplace problem or a marital problem or an intellectual property problem or an IT problem, we will politely refer them to somebody else who's got the expertise to deal with that. We generally, the president's panel is largely made up of people who are either surveyors, either QSs or in the valuation side, or engineers or architects or lawyers with a good grounding of their practice in the built environment. So they tend to bring with them to the dispute resolution space many years of experience and expertise in their particular built environment sector, and we then provide them with the training and the resources that they need and the ongoing CPD and the ongoing assessment and all the rest of it that's required in order to equip them to act as dispute resolvers in whichever discipline they're involved in, be that arbitration, adjudication, dispute, whatever it might be. Moving on my one. Is it moving on anybody else's screen, or is it just me that's frozen? Oh, there we go. And so we sort of looking at why RICS has moved over to the evaluative mediation school rather than the traditional facilitative mediation that we always used to be on. And again, let's go on again, Joe, to the next slide. So I think the first thing that I need to say is that we come at this not from a particularly intellectual point of view or theoretical point of view, as everything that we do is seen through the lens of being an appointing body. So under the RICS Royal Charter, we have an obligation to, insofar as we can, protect the public interest. And it's important for us to be able to make sure that what we are equipping our mediators to do actually meshes with what in the main we are hearing from them they are being asked to do by the public and by the applicants who come to us seeking appointments when they're out there in the field. So, you know, our move away from the classic facilitative mediation into the sort of more evaluative side of it has been driven by what we have heard back from the market and what our mediators have told us, rather than because at some point we took a position in principle that we want to make this sort of conceptual leap from one form of mediation to another. And indeed, I don't think we believe there really is a great conceptual difference between the one and the other. So, you know, that probably diffuses quite a lot of the controversy about it. But certainly we are conscious as an appointing body, dealing with solicitors, dealing with firms in the built environment. So that's in construction, property administration, project management, disputes relating to everything from party walls and neighbor disputes through to condominium disputes, through to strata disputes, that there is a real perception, negative perception of the traditional facilitative mediation process in the market to whom we provide services in the main. And it's sort of had a really bad press. By that, I don't mean in the media, but I mean in terms of what lawyers say to each other, practitioners say to each other, the representative firms that we deal with in the built environment say to each other about engaging in the mediation process. And I think part of our response as RICS has been to try and address this bad press that it's had. And I think in the main, it's absolutely unfair that the classic mediation process has acquired this bad press in our sector, because it is widely used clearly in labor and workplace, family mediation, community mediation. I mean, even if you go so far through to the sort of transformational mediation school. And it has, since the 1960s, worked exceptionally well, and it delivers, and it continually delivers. But that nonetheless, there is an undeniable perception up there, certainly in our experience over many, many years, that the people whom we would like to see using mediation and engaging mediation in the hard end of the market, if one wants to call it that, in commercial sector, in the construction sector, infrastructure sector, property sector, see it as touchy-feely. They have had experiences of mediators who quite clearly have not been specialists in the sector at all, and therefore have come in and not been able to speak the same language as the parties, and the parties feel that they've had to spend far too much time bringing the mediator up to speed to allow the mediator to be really effective in the role. Certainly have come in underprepared. And I mean, I go back to the 1990s when I trained as a mediator with the ADR group in Bristol. And I remember then being told, and as I came into this as a barrister, being quite surprised by being told that I didn't really need to read the case particularly well or be particularly up to speed with the facts of the dispute between the parties, because that wasn't my job. My job was to sit there and to facilitate the discussion between the two of them. And I must admit, you know, coming in from as being a barrister where everything is the brief and your preparation for trial, to come into a mediation suddenly being told that, oh, you don't really need to worry about that, never really gelled particularly well with me. And it certainly is a concern that we've seen reflected almost without exception, you know, across the market with the people that we deal with. And then this last one is the notion that it's insufficiently rigorous, that, you know, mediators schooled in the traditional way of doing it, which I'm sure many of us received our training in, and certainly I received my training in, it was never legitimate for us, however expert we might be in the field, and however unconvinced we were by the propositions that were being put forward by the parties, it was never seen as legitimate for us to actually express an opinion on it, or to shake them up particularly, to say, actually, you know what you are saying there simply doesn't, you know, what you are proposing in this planning application just doesn't gel with my experience of planning applications gained over 40 years of experience. You know, we weren't allowed to say that, even though it was quite clear that that's what the parties were in fact wanting us to say. So again, what we found ourselves in as the RICS, I don't know, 6-7 years ago, I suppose, we were providing mediation training absolutely steeped in the traditional method of doing it. We were using trainers who were steeped in the traditional way of doing it, and we were equipping people with a set of skills which then didn't entirely match what they were being asked to do when they went into practice, and didn't entirely match the expectations that the parties had coming to us as a built environment organization, appointing body, when seeking applications, when seeking appointments from us by way of applications. Again, Joe, could we go on to the next one, please? So we didn't instantly jump from years and years of being trained, schooled, accustomed to the old way of doing things. We didn't sort of jump from that and say, all right, let's go off and become evaluative mediators in one fell swoop. We sort of went through a process in which we said, all right, well, let's take the facilitator model of mediation. And in fact, there may well be a lot of truth in this. And this may still be the most accurate way of looking at it. We said, well, let's take the traditional facilitative model of mediation and let's tweak it a little bit to make it fit more with what our customers are asking us for. And we called it the RICS ACRE, and it was trademarked by Legal Department Mediation. And those of you who are old enough to remember that ACRE was once a term used in the measurement of land will understand the resonance of it. And it was, you know, again, it was an acronym for Analytical Commercial Restorative Expert. The analytical bit is the one that I quite like because, and I suppose as a lawyer, this is why it appeals to me. If you think about what the role of an attorney is in running a civil trial in those jurisdictions like the States, which still run civil trials in front of juries, and you say, well, what's the role of counsel in a jury civil matter? I suppose criminal as well, but jury civil. Your role as counsel is to analyze the evidence, both the evidence that heard in the witness box, together with the evidence in the form of papers and submissions and documents, to analyze the law, to analyze the arguments in such a way that you empower the jury to actually make a proper decision in the form of their verdict at the end of the case. And I think our approach to mediation is to say, well, you are being hired by the parties as the mediator because they want someone with 30 years experience in valuation, or 30 years experience in building concrete structures, or 30 years experience in tunneling under London. Why are they being so specific about what they want you to use those skills and experience for? And our argument is, well, then you should be able and free to use that experience to analyze the documentation, analyze the expert witness reports, analyze the pleadings if the matter is running in the context of ongoing litigation, analyze the submissions made by the parties, analyze their position statements, analyze the bundle, analyze the arguments, and look at and do an analytical approach in developing options for settlement and in doing your reality testing, which empowers the parties to develop a far better understanding of the matter, both from a legal and from a commercial perspective, to allow them to then reach a proper decision. But what you are doing is that you're empowering them to do so. You are not making that decision yourself, and you're not telling them what to do. It remains an evaluative process and not a determinative process. And I think that is probably where we as an institution have got to in terms of our approach to mediation. The commercial aspect, I think this is one of the really important distinctions, of course, is that if you look at arbitration, adjudication, litigation, all of those cases are confined to the pleadings. They are confined to resolving a dispute which has occurred at some point in the historical past, and by deciding on the balance of probabilities which version of events is more likely, then applies the law that is argued to be relevant, and by doing so comes to a conclusion as to where liability or causation lies in respect to something that happened historically. If I were to stand up as counsel and say, well, you know, my lord, what the parties want to do now is go off into the EU post-Brexit and build shopping centres, which is the sort of thing that people who come to us want to do, the judge would say to me, well, you know, is that in the pleadings? And you say, well, no, my lord, why are you mentioning it? It's inadmissible in court. And obviously that's quite correct, because a court, an arbitrator, and an adjudicator looks at a set of historical circumstances. Everything they do is retrospective in its operation, and their job is to decide what happened 4 years ago when the matter is. What the parties want to do now, the commercial realities between the parties now, the commercial ambitions that they might have, has got nothing to do with the resolution of a court case or an arbitration or an adjudication. But mediation is all about it. Because mediation, ultimately, the way we look at it is that it is not a legal process, it's a commercial process, which normally takes place within the shadow of a legal process, but is not in itself a legal process. And I think that is a fundamental distinction that we need to make. It's restorative. I mean, particularly in our neck of the woods, there are very often a limited number of suppliers, a limited number of consumers, and these firms need to work with each other. So, you know, we've been working on the conflict avoidance process now with Transport for London for 4 years. We've dealt with nigh on 80 cases now, I think, where they have, and they are, I mean, they're dealing with 5 organizations, Taylor, Lang O'Rourke, Taylor Woodrow, BAM, Skanska, and one other. And it's the same 5 principal contractors and the same client, and they have any number of different disputes arising out of all the work that's been done on extending the tube and so on. But, you know, part of what we do is to make sure that that business relationship between those parties remains good. Which sending it to adjudication undermines that relationship. Dealing with it through some sort of mediative process does. So it's restorative in the sense that it's either restores a relationship that has been damaged, or put it the other way around, it maintains a relationship as well as it possibly can be. Expert, we've talked about this already, we tend to use people who can bring with them the expertise that will allow them to make a real contribution to developing the parties' genuine, incisive, insightful, and analytical understanding of the dispute, so that they are empowered to make a proper decision. Okay, Joe, can we go on? I think I probably talked about this one already. So, I mean, what prompted us to make the move was the demand from the applicants. So, you know, we have received quite literally application forms, and I'm thinking of one particular one in Saudi, which was a real example of this. There were pages, literally pages of requirements from both the parties as to the experience and expertise that they wanted the mediator to bring to the thing. So they wanted, I mean, without breaching any confidentiality, it related to a power plant, or you know, a facility related to the oil industry in Saudi, where there was an issue relating to certain machinery not doing what it was supposed to do. They wanted familiarity with NEC forms, they wanted familiarity with FIDIC forms, they wanted familiarity and a working knowledge of the sort of bastardized form of standard contract that they tend to use in Saudi government. They wanted a lot of experience in the Gulf. They wanted experience in the petrochemical industry. They wanted experience in both chemical and mechanical engineering, because they're elements of both. They wanted an awareness of accounting principles, because there was a big dispute about the way certain monies had been accounted and finally they wanted 20 years experience in the Gulf, and they wanted fluency in Arabic. Well, given that the clients were a consortium of multinational companies, given that the people running the company from the Saudi side were a scion of the royal family who had gone to university at Harvard, we didn't really think that fluency in Arabic was absolutely essential. So we dispensed with that one. And I remember we landed up with three possibilities, one in Australia, one in the Middle East, and one in Scotland. And we ended up flying all three of them to Saudi to go and meet the clients. And one person eventually took on the job. So, you know, this demand for sector expertise and experience was enormous. And what they had in mind was not the sort of classic 1 day, 2 day mediation that I think we very often think about, and upon which most mediation training, including our own, is premised because it's the most useful way of teaching people. But what they had in mind before the matter went to arbitration, and they got on with it. Akrama, does that mean there is no chance for small mediation, for such mediation deals? At that level, probably not, to answer your question properly, Akrama. But we get loads and loads of other applications for mediations between neighbors who are having a fight about, I mean, one that we dealt with a few weeks ago, there was a parking space between two properties which were 4 paving blocks by 8 paving blocks, if you can imagine that. And the argument was that the row of paving blocks closest to number 88, in fact, belonged to number 88, and it was being parked on by number 86. And that was what the dispute was about. And it was, you know, to whom did that last row of paving blocks belong, and what we were going to do about resolving that issue, because the other person had parked on them for the last 20 years. So, you know, Akrama, that one quite clearly went to, in your words, the small mediator. All right. So it's literally horses for courses in this job. Does that answer your question at all? Yeah. Okay. Brilliant. This is the feedback we got from our mediators. We realized that our training and our communications were not really reflecting reality, because we were training people in the facilitated model. We were communicating to the world that that's what we offered, but we knew that that isn't what our mediators were being asked to do in practice. They were being asked to express an opinion, in essence, on the merits of the propositions being put forward by the two sides. Not necessarily to tell the parties what to do, but the parties are saying, you've been in this job for the last 30 years. What do you think about either what we're saying or what the other side are saying? And we therefore, you know, as a Royal Charter institution, there was a risk, because we were appointing people on one basis, knowing full well that they were being required to act in a different basis by the parties, and in a way that we hadn't actually equipped them with the skills that they needed in order to be able to handle the challenges that were being thrown to them in practice. And so it's for that reason that we decided to move. So again, Joe, if you can move on, and we can probably whip through these quite quickly, move on. So those elements all remain in place. The mediation remains, no, sorry, if you can go back one to the one that's got the table of elements on it. That's the one, thanks, Joe. So all of those elements remain in place completely, nothing changes. It still remains a voluntary process. And I mean, you can argue, you know, what is voluntary, you know, from jurisdiction to jurisdiction, given the amount of pressure that's being put on parties to go to court, but that's beyond this afternoon's discussion, by which the parties to the dispute are assisted by a neutral third party to negotiate a settlement. I mean, those elements, and I mean, that's probably as good a definition of mediation as you're likely to get, I think remain absolutely untouched by the move. If you can move on, Joe, I see I've already dealt with the next slide, dealt with that, move on to the next one. So, I mean, the first thing is, if you say, what do we mean by, or what do we understand by evaluative mediation? I don't want to dodge the central issue, which is that, to me, the way I was taught and the way this has been relayed back to us over the years is that the real difference is that an evaluative mediator is free to actually express an opinion on the merits of a proposition being made to them during the course of the mediation in order to assist the parties. Whereas in the old days, I was certainly taught that it didn't matter what you thought, you didn't say it to the parties. And where you did do reality testing, it was all the sort of slightly mealy-mouthed business of saying, oh, well, you know what, if this were put to you under cross-examination, how do you think you might deal with it, even though it was perfectly obvious that the fact that you were asking that question made that you thought it was a load of rubbish in the first place. So, you know, but if you want to go back, you can take a few steps back, you know, conceptually if you want to. So all mediations are evaluative to some extent, I think, and I think that's true. So I defy anybody not to draw conclusions in their own minds when they read a set of papers. You know, judges do it, arbitrators do it, everybody does it. Any intelligent human being reading a set of propositions will draw certain conclusions from it. And the whole point of then going into a role as a judge or an arbitrator is that you will then take pains to ensure that you have whatever your pre-ideas are addressed properly during the course of that process, so that you can disabuse your mind of any preconceptions that it may have made simply from reading the papers. That's the point of evidence. That's the point of argument. And again, in mediation, you're not going in there, or doubly so in mediation, you're not going in there to tell the parties what to do. You're going in there to hear what they say. But are you going into it as some sort of tabula rasa, some sort of blank slate? Well, you know, I think you're not. Because you've read the papers, you have drawn some pre-conclusions from what you've read, and you're going to have to make damn sure that during the course of your time that you spend with the parties, particularly in private session, that you actually raise those points with them and you make sure that they have the proper opportunity to address you, or to talk to you about it, to make sure that, you know, these issues which have occurred to you, which have undoubtedly occurred to the other side, have been explored and analyzed properly. You will evaluate which process will work best. Are you going to keep them together? Are you going to see them in joint session? What issues you're going to deal with first? What sort of agenda are you going to create for the mediation process? None of those decisions are made without an element of evaluating how best to deal with the personalities, the individuals, and the matter of the dispute that you're actually dealing with. So again, I think for us to turn around and say we're not being evaluative, it's not just semantics. There are real elements of evaluative reasoning that go on even in the most traditional approach to mediation. When you decide what questions to put to the parties and when, there's a huge amount of evaluation going in there. Because very often you actually wanting to get to the bottom of something, you reckon that something is not quite kosher, and you want to see what's lying beneath it. And you're going to order your questions and structure your questions in such a way that doesn't cause them to clam up, that gets the parties to actually engage, which gets them to recognize that there are real challenges to what they're saying, and that they need to look into this more deeply. Again, when you're developing, you're exploring options, you're sitting there and they're saying, well, you know, what are we going to do? We could just walk away. We could offer them a new contract. We could offer them a franchise. We could offer them a license agreement. You know, we could just cave in and pay them what they want. What's the effect going to be on us? What's it going to be on our business relationships with our competitors, with our associates? What's it going to be in terms of any future work that we want to deal with, you know, to do with this particular entity that we're working with? It's almost impossible to have those sort of intensely useful, intensely valuable discussions with people without there being an evaluation of the merits and demerits of those various offers as they're being developed. And then finally, in your reality testing, you know, in my early days in Wales, and we still had to pay money to go across the bridge from Bristol in those days. And, you know, meeting these people, there'd been any amount of development going on in the valleys, which seemed to, and what people seemed to get didn't really tie up with what they'd seen on the plans. And these were the sort of disputes that they had. And you were endlessly reality testing people and trying to wrap it all up in a way that didn't make it sound as if you had thought that what they were saying was rubbish. But yet they knew, and you knew, that is exactly what the dynamic was. So it's in all of those things, there's an element of evaluation. And I think for us to sort of try and pretend as mediators that we're not deeply evaluative in everything we do is probably not really, I don't think it pulls away over anybody's eyes. I think people recognize it for what it is, and the public aren't stupid, and they do recognize that. Can we go on to the next one, possibly? Please, Joe. I've just seen, I've been waffling for far too long. So you'll all be familiar with the Riskin grid, and you'll also know that 3-4 years later he moved away from this. But nonetheless, when you go back and you read the literature on evaluative mediation, so much of it and so much of the controversy emanated from the positions that Riskin came out with in the first place. And I think if you look up that grid of his, which goes from narrowly defined problems on the left to broadly defined problems on the right, and from the facilitative model to the evaluative model at the top. For us, I mean, we generally tend to find ourselves operating in the narrow side. We're dealing with the legal and the commercial issues. We're not dealing with the community, personal, issues that are sort of on the broader side. But even if you go through the narrow, if you start at the bottom, what are the behaviors of a facilitative mediator? Asks about the strengths and weaknesses, asks the likely court or other outcomes, asks about consequences, helps parties develop, exchange narrow position-based proposals. And then you sort of get up to the cusp, helps the parties evaluate proposals, all right? How do you do that without an evaluative idea of your own? Then going up to, and I'll come to you, Akram, in a minute, how can we guarantee unconscious biases while evaluating? You can't, is the answer, Akram. You can never guarantee it, any more than a judge can guarantee it in hearing a case, or an arbitrator can guarantee it. You will have some unconscious biases. That's part of you. All you can do is alert yourself, and part of your professional responsibility as a mediator is to be conscious of your own unconscious biases, but to behave in such a way that the mediation process itself assists you as the mediator to hear and to deal with both sides of the story as much as anybody else. And I think the comfort that we can draw from being mediators, rather than being, I mean, I've often sat as an arbitrator where you sit and it's your job at the end to make a decision which actually binds the parties. And there, the issue of your unconscious bias is really critical, because if that creeps into your ward, which is largely unappealable, the parties have to do what you say. Whereas here, even if you're acting as an evaluative mediator in our model, you are still assisting the parties to reach it. And what you're trying to do is to make sure that the mediation process mitigates any possibility that your unconscious bias might have of influencing that process ultimately. But no, I mean, there is no guarantee. Manifestly, there can't be in any human interaction. There will be unconscious bias. All we can do is allow a system which has evolved over 50 years, 60 years, as mediation has, I think, and has evolved very successfully because it does mitigate against that in the process itself. So if you move over to what an evaluative mediator does, so assesses the strengths and weaknesses of each side's case, we do, predicts court or other outcomes when asked, and proposes agreements, yes, fine. And then you got up to that last line, which Riskin initially defined, but then later moved away from, saying that the evaluative mediator, it's within the legitimate ambit of what an evaluative mediator does to urge or push the parties to accept a narrow-based settlement. Now, we've got huge problems with that, because to our mind, that is when you move over the cusp and you become determinative rather than evaluative. If that's what you want to do, then the parties must engage you to become an expert, to do an expert determination. And they can come back to us and we will quite happily charge them an appointment fee, and we'll appoint somebody to do an expert determination for them. Yeah? But then that person is not acting as a mediator. The role has changed. In practice, do people sometimes get sort of pushed over the edge? Well, yes, I think one must be honest and say that they do, but they should absolutely resist that, and there should be complete transparency between the mediator and the parties when that sort of dynamic develops during the course of a mediation. And the mediators should not unwittingly allow themselves or the parties to find themselves in a situation in where the mediation has morphed into an expert determination. And I think that is where we draw a very, very clear line. Okay, again, Joe, could we move on, please? And I think the next two slides perhaps tell you that. So the golden rule as we see it, with with all due acknowledgement to Marcus Queck for having sort of established the principle of party self-determination, is that you as the mediator always express an opinion to grow the party's understanding of the issues, to increase the amount that they consider the case, to empower them to settle. In contrast, you never express an opinion which reduces the amount the parties consider the case by simply adopting your understanding understanding of the issues rather than developing their own. And in so doing, you disempower them. And to us, that's the really crucial thing. Somebody put up a question and I was busy talking and it's gone. Joe, how do I get it back? Do I go into the chat box? Okay.
Have you got it?
Yeah, I've got it. That's from you, Steve. Yeah, okay, I'll come back to them in a minute. So I think the point that we're really making is really summed up in this. So as an evaluative mediator, if you see the difference being that you can legitimately express an opinion on what's being said to you, how do you manage that process? And to us, so long as you're expressing the opinion in such a way that it actually increases the party's understanding of the issue, and in so doing, empowers them to settle the matter, then that's fine. If what you're doing is that you're inviting the parties to relinquish their own critical faculties and to simply latch onto whatever you say as being the solution, then you're no longer empowering them, you're disempowering them, and that is where it becomes problematic. And so our challenge to anybody who operates as a mediator with us is that you need to manage that relationship very, very carefully. But there's nothing new to mediators. I mean, there've always been thorny issues that you need to manage in mediation, from dealing with confidentiality through to, issues that even in the facilitated model, when you're reality testing, would have brought you face to face with this dilemma. So Joe, could you go on to the next one again, please? So in plain and ordinary English, you're empowering the parties to make a sound decision. You're not telling them what to do. Okay, just in plain English. So Steve, John, would you appoint the same person as expert who is appointed mediator, thinking about party costs here? I don't have a complete answer to that, Steve. My normal sense would be no, because if you have gone through a mediation where you may, as the mediator, have sat in private session with the parties and become privy to confidential information, I don't think you can, even if you can, expunge that information from your own mind in the way in which you then render your decision as an expert making an expert determination. A perception of your possibly having been exposed to confidential information may well exist in the minds of the other party, such as to undermine your neutrality. And so we would generally, under those circumstances, not appoint. On the other hand, if what you have got is, as is quite often the case in construction, you've got both parties, they've been to mediation, everything that is going to be said has been said, there's nothing particularly confidential, there's nothing particularly new. We're talking about whether what was done met the specs or whether the contract was properly managed or enforced. And there's no great mystery to the whole thing. And both parties actually say to us, you know what, we just want Steve Campbell to now tell us what he thinks, and we've agreed that we'll do whatever he says on this. Well, in which case, sure, we're going to appoint you. Because there the danger of your having been privy to confidential information has been negated by the party's expression of a desire that you should act as it. So there's no one principle, there's no one rule that fits all cases, but those would be the issues that we take into consideration in deciding what to do. Does that answer your question at all? All right, good, thanks, Steve. Joe, let's move on. I was conscious of time, I've waffled far too long. So some of the goalposts, and if any of you are wondering about the rugby field, that's about 200 yards from where I'm sitting. That's the closer rugby school where the game was first played, when William Webb Ellis picked up the ball and ran with it with a manifest disregard for the rules. So there we go. So mediation's commercial settlement process, it'll always be there. Settlement, you can consider personal, commercial, technical, legal aspects with them as they wish. You rely on your own knowledge as an expert, as well as what you learn during the mediation. They may ask you to express opinions on the aspects of the case, whether pros or way forward, and you're always entitled to decline to express any opinion, withdraw as a mediator completely without needing to give reasons. That last point is a whole afternoon's worth of discussion in itself, which is way beyond the scope of this hour. But we always insist that that's there, because if, particularly, as a facilitative mediator, if you hear something which is really worrying from the one side, you can still sort of carry on talking to the other side. So for instance, here's an example. I hear from the conversation that I'm having with one side that they are actually in real financial difficulties and are very likely to go insolvent. Now, I could go and carry on talking to the other side and listening to what they've got to say without ever expressing an opinion on that issue. But if the other side are asking me to express an opinion as to what they're proposing, and yet I know that what they are proposing is fundamentally impossible of achievement because I have heard that the other side are going to go bang, how can I express any opinion to them, even on a sort of unrelated technical topic, knowing full well that it's almost creating in their minds the impression that this is viable, when I know full well that from a financial perspective, it's never going to be viable. So, as an evaluative mediator, and I say probably because I think for every example, you can probably come up with a counter example, but I think just gut feeling, as an evaluative mediator, you probably are more exposed to that danger than you are when you're acting purely in a facilitative model. And so this opt-out is absolutely essential. We make sure that that is written into any mediation agreement or agreement to mediate, that the parties and the mediator sign. Jackie, do you need special insurance as a mediator for this, expressing an opinion? I don't think so. And certainly what our lawyers have told us is that so long as what you're doing is that you're merely answering a question that has been put to you by the parties and you're not directing them to do something, you probably are at no greater risk than you would be otherwise. Which is why, again, maintaining that distinction between being determinative and being evaluative is so essential. And I think possibly the answer to this, Jackie, is that for many, many people doing apparently facilitative mediation in the built environment space have been de facto expressing opinions for decades. And it hasn't given rise to any particular claims of insurance. I'm not aware of anybody having been sued. So, in terms of the sort of actuarial aspect of it, it probably doesn't increase the risk of the insurance company. Is that
I'm not convinced
sort of,
about
I can see you not completely convinced, Jackie.
No, I'm not, because as a mediator, I no longer have the insurance provision I had as a solicitor.
Yeah.
When if you're sued, you have insurance.
Correct.
I have very, limited cover as a mediator.
Okay. But what are they going to sue you for, Jackie?
Well, if you express an opinion and that opinion is wrong,
yeah,
then they could say, well, we based our whole settlement on your opinion. Correct. And it's all gone wrong, and we're going to sue you.
Yeah, but then, the way you cope with it, of course, is that you put the disclaimers in the contract to agree, in which you say that the limitations, let's just go on to the next one, Joe, the next slide, in which you make sure that in your contract you are wrapped up in the normal disclaimers.
Yeah,
so
okay, but
there's a limit. Yeah.
They're not watertight, are they?
Well, nothing's watertight, but on the other hand is that we know that for 20, 30 years, people have been expressing opinions as mediators. No one has been sued yet. So, Jackie, A, how big is the risk actually? And B, if you do put the limitations of liability in your contract and the parties have agreed that that's the case, they're going to have quite a job to persuade a judge that having agreed that there will be no liability of any errors of your opinions, however made, they can now sue you for it. And that's the purpose of a contract. Otherwise contracts have no purpose at all, which as a solicitor, I'm sure is a position you're not going to be taking. I take your point, nothing is watertight, but I mean, you can make it as watertight as possible. And the reality is, it's not as if mediators have been overwhelmed by litigation on this point. So, I hope that I'm not going to be proved wrong tomorrow with a writ arriving on the doorstep of one of our mediators, but I'd be surprised, to be perfectly honest. Because part of what you're explaining to the parties all the way through, and part of an intrinsic part of the process, is that your knowledge, even of your own field of expertise, is finite. You can only express an opinion based on what they've told you. You don't know all the facts. You're not a judge, you're not an arbitrator, you haven't had the benefit of extensive evidence being subject to cross-examination in front of you. And it's not a trial or arbitration, it's a limited commercial settlement, generally taking place in a day or a couple of days. So within the context of all of those clearly stated limitations, you know, they're going to be quite hard pressed to say that in the face of all of those clearly stated, transparently admitted limitations, they suddenly, oh, you know, we settled this case between us because that's what the mediator told us what to do. Quite an evidential burden to discharge, I'd have thought, under those circumstances. As I say, we ain't seen a single example of it in 30 years yet. So I don't want to sound overly confident on that score, but I'm got my fingers tightly crossed. And so far, there's nothing that we've encountered to suggest that a contractual disclaimer limiting the liability to assume no responsibility for any errors does other than that in terms of their ability to sue the mediator. I don't think I can take it much further than that, actually, Jackie, probably. I think we're running out of time, so I'm not going to, we can just whip through a couple of slides, Joe. I just want to do, let's go on. All of this dealt with. Okay, let's have a look at a couple of these. So I just wanted to give you a sense as practicing mediators, as I think I saw from the survey you were filling in that most of you are. If you ask me, sort of heading the dispute resolution service, where I see mediation going, I think there's a lot of growth in actual sort of conventional mediation, if one sees it that way, of parties going to a mediator to resolve a particular problem. But what we're also seeing is the business of mediation becoming increasingly incorporated into other dispute resolution or conflict avoidance processes that are going out there. And all of these ones here, but I mean, particularly the Transport for London one, under the EU directive on collaborative contracting, TfL, because they are publicly funded, were obliged to have a mechanism in place to encourage the use of collaborative contracting and early conflict avoidance in their standard, generally versions of NEC3 and NEC4 contracts with their major contractors. And what we did was worked with them to set up a conflict avoidance process by which if either TfL or one of the major contractors, and then it went right the way down the chain ultimately, became aware of an issue which had the potential to go to adjudication, they could then invoke the conflict avoidance process by which we would appoint a 3-person or single-person panel who would then, in the first instance, use evaluative mediation techniques to bring the parties as close together as possible and to exclude from the consideration all those peripheral issues which were not the central point in dispute. And if that failed to resolve the problem, would then produce, drawing on the adjudication model, within 28 days, a written recommendation which was non-binding, but fully reasoned recommendation as to what the parties should do. We've disposed of about £400 million worth of disputes using this mechanism over the last couple of years. It's sort of heading up towards 80 cases being sent to us so far, and every single one of them has, in fact, worked. They have ultimately been resolved without going to adjudication, much less arbitration or litigation. And the point that I'm making today is that although most of those cases have required a written recommendation to be made, and bear in mind there's no private sessions there, so the issue about confidential information doesn't enter into it. And the same person has initially worked as an evaluative mediator and then has gone on to effectively producing the recommendation, which is a non-binding recommendation. It's worked, and it has kept those cases very successfully out of court. And what's more, it has maintained that relationship and reduced delay with the execution of the contracts. And this was written as an additional clause into the NEC3/NEC4 contracts that were used on the £6 billion worth of contracts involved. So it has worked exceptionally well. And if you go on to the next one, please, Joe, this is a slide that was produced by TfL, not by us, as to the the effect of the implementation of that service in 2016 on the number of cases that they had that went to adjudication, which are the red cases, and the agreed events, which are cases which ultimately were agreed between the parties, but not until a great deal of time, energy, and money had been spent on the process. And you can see the effect that this had on that. So those figures came from TfL, and I think they are pretty dramatic, you know, reflection of how successful that sort of conflict avoidance process, central to which is an element of mediation, can be. And I take great joy out of this, because I think that this move away from dispute resolution to conflict avoidance is, I think, where we are going to see a sea change over the next decade or two. And it's good to think that the mediation skills and capacities of people such as yourselves can be central to this process. And I think that's a very exciting development as far as we're concerned. Moving on quickly just through the last couple of slides. Running in parallel with this has been the creation of, and you're going to have to tick the button because I think it's got embedded stuff in these slides, please, Joe, and we'll bring up, if you just keep on pressing next, it'll bring up the slides. Yeah, there we go. It's one of those slides. Yep, that's it. Thank you. So in parallel with this, we created the Conflict Avoidance Coalition, where we're working with CIAB, ICC, DRBF, REBA, and us. And you know, the role of the coalition has been to encourage the use of conflict avoidance and early dispute resolution mechanisms in the infrastructure space. And it is, we brought out, if you go into the next one, Joe, the Conflict Avoidance Pledge, which is an online pledge which has been signed now by well over 200 organizations across the country, where in essence they agree that they will engage in collaborative contracting, they will encourage their manpower to use it, their staff to use it, they will incorporate conflict avoidance provisions in their contracts, and they will use conflict avoidance mechanisms to deal with matters rather than sending them through to adjudication, litigation, or arbitration. On the next slide are some of the people that have signed up to it, and you can see it's being well received. And I know that, is it on there? Heathrow signed up only recently. I don't think we've quite updated the slide to have Heathrow on it. Oh, I think that's an old slide because Carillion's still on it. That slide has since become outdated, but nonetheless. And that's it. Thank you. So Joe, if you can move on. People, that's sort of a canter through the approach that we've taken, why, and the way in which it's sort of spreading out into the industry.
Thank you so much, John. We have got